they supply these items to Zombo district. I think these are my prayers. Thank you very much.
Honourable members, yesterday the member for Pakwach raised the same issue about the absence of masks in the high-risk area. We now similarly call on the Ministry of Health to update us on the distribution of masks to the 40 districts, but specifically to Zombo, which has also been raised, and give us an update next week on Tuesday. Thank you. Let's go to item 3.
Item number 3, statements by ministers on the status of implementation of parliamentary resolution on payment of monies owed to Uganda South Sudan traders.
Again, I don't see the Minister of Finance.
Item 3.2.
Yes, Honourable Machu.
Right Honourable Speaker, in the Sub-Saharan Africa, Uganda has the biggest cabinet. Right Honourable Speaker, in the East Africa countries, Uganda has the biggest number of ministers in the docket of finance. Right Honourable Speaker, the status of Uganda now needs urgent attention due to the economic pressure that our people are facing. Many times this matter has come on the floor, and matters concerning finances apart from borrowing, whereby the quorum of ministers in parliament is full. When it comes to borrowing, even the ministers who are on sick beds move and come here. At the same time, Honourable Minister, Right Honourable Speaker, I know other ministers are still facing political pressures that they have incurred during the recent primary elections in the NRM. But me, I believe it is intention and it is deliberate for ministers in the docket of finance to fail the work of Parliament due to their behavior. Therefore, I don't know whether we are proceeding well when matters come to issues affecting the economic status of our people, for the ministers of finance always to be absent. And not only the ministers of finance, as you see and as you agree with me today, out of a cabinet of 80, we have only one cabinet minister. If people are not capable of taking over their dockets, I give a request to my party chairperson that he should give people who are capable of being ministers to work for him, because this means that as NRM we are failing information.
Honourable members, the matter of the issue of South Sudan has been on the order paper for a long time. For now, I think we shall not entertain work of the Minister of Finance until this matter has been resolved, including what is on the order paper. It will not be handled. Item 3.2.
Item number 3.2, statement by Minister on distribution of tarmac roads in Uganda.
Minister of what? Absent. Item 4.
Item number 4, laying of papers, Petroleum Authority of Uganda Annual Report 2016-17.
Minister of Energy. Yes, Minister.
Right Honourable Speaker and Honourable colleagues, I'm just standing in to give information to you, Madam Speaker, and to the House, that today there was a special cabinet. Personally, I didn't go there because I'm yet to sort my COVID status. So most ministers and the lead of government business could be still held up in cabinet. So I beg, Madam Speaker, that that should be put into consideration. Thank you.
Right Honourable Speaker, I know Honourable Frank Tumwebas as my friend, and one of those ministers who are very rare here in Parliament ever since he became a minister. Though before, when he was the chairman of Committee of Finance, was regular here as a backup bencher. Honorable Speaker, in our constitution and our legislation, it is you, Madam Speaker, who is supposed to be given any information between you, the President, and the leader of government business, who is the Prime Minister. Honorable Speaker, you have always, ever since this House started from COVID, one of the rare people here is the Prime Minister. Yet he's supposed to be updating this Parliament on a number of issues, including COVID. Now, when the Minister of Gender, the Honorable Frank, comes in to defend the other ministers when he's here, is he here in order? Yet you have not been informed as the Speaker of Parliament, who is supposed to get first-hand information even before he comes to inform the House. Honorable Speaker, this is the right time for members to shine. Members have been in constituencies fighting. Others were almost killing themselves, fighting for this Parliament. You put information directly to every member, even the public, that Parliament is resuming on Tuesday. We who are responsible, who are carrying out our duty, are here. Then the minister is coming in to defend his fellow ministers, meaning that he has tried to disobey the president who called them. So is he in order, Madam Speaker, for him to come on the floor of Parliament to defend others, whereas he's here? Is he in order? Yet you are the one supposed to get first-hand information. Even if you want to add here in this House, you have the prerogative to do that. So is he in order to come here to mislead this House? Yet these people have been killing themselves, fighting, and they are failing to respond to your call and the purpose why they have been fighting to become.
Honourable members, I have no information about any cabinet meeting. I'm aware that cabinet meetings takes place on Mondays. Today is Wednesday. We shall proceed. Moreover, notice was issued last week about our intention to sit during this week. So I'm not going to listen to any excuses, and it's incumbent upon you, the government people, to ensure that at least every minister is represented here. Item 4B, 4.2.
Item 4.2, laying of papers.
Absent. Item 5.
Item number 5, motion for resolution of Parliament on the commemoration of the International Day of Democracy.
Honorable Kamba. Where is he? Item 6.
Item number 6, motion for adoption of reports of the Committee of Natural Resources and Environment on government proposal to construct a hydropower generation plant over Action Falls.
Chair of the committee? Absent.
Item number 11, Bill second reading, the Labour Disputes, Arbitration and Settlement Amendment Bill 2019.
Honourable Minister, the bill was given a first reading. The report was presented, but there were issues that you were expected to respond to under the Labour Disputes, Arbitration and Settlement Amendment Bill, which your new minister was not able to handle. The Honourable Kanyike moved the bill for second reading, but she was not able to respond to the concerns of the members.
Madam Speaker, thank you for having accepted my apology when I was unable to be here because it was 5 days to the primary election. I spoke with you and explained my difficulty. So when I was Sarah Kanyike, who was a maiden member, I had to stand in then. I thank you and Parliament for the extent to which you were able to progress with the law. As far as I know, Madam Speaker, we are at par. We are in concurrence with all the committee recommendations. And I therefore request, and if it's acceptable, Madam Speaker, that we move on. Either debate ensues if it hadn't been concluded. We continue, Madam Speaker, with the committee stage.
There were issues raised on the floor there were issues raised by the members during the debate, which we thought we could answer before we go to the committee stage. I don't know whether you have them.
Madam Speaker, I beg your indulgence. I don't have a record of the concerns.
Okay, members, bills, second reading. Were there any members who wanted to contribute on this? If there are none, where is our chair? Onakunhira is here. Okay. But maybe before we go maybe we go back to item 5, because it was a short matter on the International Day of Democracy, as we are maybe picking up the issues which were raised in the absence. Can I invite Rhoda Bakamba to move the motion?
Thank you, Right Honorable Speaker. Right Honorable Speaker, I move a motion for a resolution of Parliament on the commemoration of the International Day of Democracy under Rule 55 of our Rules of Procedure. Whereas in 2007, the UN General Assembly adopted the 15th day of September as the International Day of Democracy, and since then, the International Day of Democracy is celebrated around the world each year with the purpose of promoting and upholding the principles of democracy. And whereas yesterday the world observed the International Day of Democracy under the theme COVID-19, a spotlight on democracy. Aware that the International Day of Democracy provides an opportunity to review the state of democracy in the world and encourage governments around the world to strengthen national programs devoted to the consolidation and promotion of democracy in their respective countries. Appreciating that democracy is a universally cherished value based on the free will of the people and provides the natural environment for the protection and effective realization of human rights. Appreciating further that Uganda is governed based on democratic principles enshrined under the political objectives of the national objectives and directive principles of state policy of the 1995 Constitution, which among others enjoins the state to encourage and empower the active participation of the people of Uganda in their governance. Noting that Uganda, being a part of the United Nations and a member of the Interparliamentary Union, is duty-bound to recognize and celebrate the International Day of Democracy as a means of building democracy and democratic institutions like Parliament and strengthening the voices of citizens to strive for the realization of shared universal values of democracy. Aware that the 2020 International Day of Democracy comes at a time when the world is faced with an unprecedented COVID-19 crisis, which has resulted in major challenges to democracy, hence the theme for this year. Further aware that as the world confronts COVID-19 pandemic, democracy is crucial in ensuring the free flow of information, participation in decision-making, and accountability for the response to the pandemic in order to achieve a holistic approach to the pandemic. Cognizant that the International Day of Democracy enables democratic countries to take stock of the challenges posed by the COVID-19 pandemic on democracy and find ways to counteract those challenges. Now, therefore, be resolved by this Parliament that Uganda joins the rest of the world in observing and commemorating the International Day of Democracy. The government of Uganda reaffirms its commitment to observing democratic principles enshrined in the Constitution and international legal instruments, even in the face of the COVID-19 pandemic. I beg to move, Madam Speaker.
Thank you. Are there seconders? Motion seconded. Seconded. Justification.
Madam Speaker and honorable members, today we join the rest of the world to commemorate the International Day of Democracy. Due to the COVID-19 pandemic, the theme recognizes the challenges of attaining democracy amidst the COVID-19 pandemic. Madam Speaker, objective number 2 of the national objectives and directive principles of state policy recognizes democratic principles which, among others, empowers and encourages the active participation of all citizens at all levels in their own governance. The above has been recognized further under Article 1, which gives all powers to all the people who shall exercise their sovereignty in accordance with the Constitution. But most importantly, under Article 1, Clause 4 of our Constitution, the people shall express their will and consent on who is to govern them through regular, free, and fair elections of their representatives. Madam Speaker, in Uganda, not even the COVID-19 pandemic is stopping us from implementing the provisions of Article 1, Clause 4 of our Constitution. The government is determined, and indeed the process has started, of the people of Uganda deciding on who should govern them in the coming political term. And Madam Speaker, this should not be underrated. Not very many countries have managed to organize elections in this pandemic, but Uganda has, and indeed it is organizing the general elections, and we hope that in 2021 we shall have a successful general election amidst the COVID-19. And Madam Speaker, as we join the entire world to commemorate, we just enjoin our government to ensure that as we implement the principles enshrined in our Constitution, the democratic principles, we should not overlook the rights, the human rights that are enshrined in the Constitution, because you cannot talk about democracy without looking at the human rights of Ugandans. So I enjoin the government that as we commemorate, let us ensure that every Ugandan enjoys the rights as enshrined in the Constitution. Every Ugandan participates in the decision on who should really govern them. And I know that we shall continue observing these democratic principles. And for that matter, I beg to submit that it is befitting of us to join the rest of the world in commemorating this very important International Day of Democracy. I beg to move.
Thank you very much. Any seconder? I don't see the seconder. Honorable Nwagaba.
Madam Speaker, The topic brought by my friend is very important, especially in these times. We do know that every right has a corresponding responsibility. But our rights as Ugandans, particularly to participate fully in democratic activities, has been grossly affected by this pandemic. Unfortunately, however, we now have a situation where some rules have been put in place to restrict the obvious rights, particularly the right and freedom to associate, the freedom of movement, among others. But when it comes to enforcement, the enforcement of those limitations seems to be one-sided. It tends to militate against those who hold different views and opinions from those of government. And it is befitting that this particular motion has come at this time, and it is up to government, if it is truly interested in enshrining the principles of democracy in the Constitution, that all citizens of Uganda, regardless of their political opinions and shades, be treated equally, notwithstanding the challenges of this pandemic. With those few remarks, I support the motion.
Kamateka? Okay. Kamateka, Macho, Timuzigu? Yes, Amede? Okay, those four. Otieno.
Thank you, Right Honorable Speaker. I want to thank our colleague, Honorable Akamba, for bringing the motion that indeed Uganda should join the rest of the world in commemorating the International Day of Democracy. It is unfortunate that we are debating it a day after, but creation of awareness is very important, and also commitment. Right Honorable Speaker, yes, as Honorable Nwagaba has mentioned, we are in this process now of electing leaders for the next term. The exercise we've just had, yes, is party primaries, and issues will be taken to party caucuses. But it is important for us to note that in order for Ugandans to be able to participate fully and meaningfully in democracy and elect their leaders democratically, government should come out and carry out sufficient sensitization of the masses, of all people of Uganda, that they know how to elect their leaders, and that they also know their responsibilities as citizens. For example, Right Honorable Speaker, in the just concluded primaries, we had children who were lining up to vote for candidates, and you would wonder, what does a child know about electing a leader for the future? And why would the leaders, those entrusted with the process, let such children vote? So I think we have that responsibility to ensure that there is sensitization, that even our children know that they are children and they are not supposed to vote until they are 18, so that they are adequately guided. Secondly, Right Honorable Speaker, that people who are put in positions of responsibility to ensure smooth running of processes, that indeed they are held accountable. Because you leave people hurting, you leave the nation hurting, because the leaders that were supposed maybe to be elected do not get elected because of a faulted process. So we have that responsibility. Of course, we are all affected by COVID, and we agreed that the electoral process should be, the campaigns should be digital, but you'd get amazed that people get onto TVs and radios only to tell lies, only to abuse others. So we also need to have that element of a sense of responsibility, and also maybe to hold leaders or to have systems as regulations as to what should be aired on national radio and TVs, rather than mislead people, rather than go there to abuse fellow Ugandans. I think we need to build a culture of respect if we, in order for us to have leaders able to move Uganda forward. I thank you.
Thank you, Honorable Macho. 2 minutes. Then Honorable Tumuzigo, 2 minutes. Amede, 2 minutes. Otieno.
Madam Speaker, I really want to thank my colleague, Honorable Kamba, for such a wonderful motion. Democracy is very important for the development of any country. And the motion comes at a time whereby Uganda, we are going through political participation. Madam Speaker and my colleagues, I look at this motion as an issue that will help political parties to build their internal democracy, whereby in our country in particular, people think parties belong to a person than parties belonging to people. And this will help us to build good governance so that people own the governance of a country. At the same time, Right Honorable Speaker and my colleagues, this brings COVID as a hazard that has mixed up the politics of major country, which has helped many ruling governments in East Africa. I give an example of Kenya, whereby the ruling government is using COVID to block other people who would have been free to express their political views. And this one, we see it as a factor that will hamper the coming elections, general elections in this country. I therefore call upon we legislatures here that we should support freedom of expression and freedom of our people so that they participate freely. That's why what UCC, Uganda Communication Commission, has started of making sure that people must register by force, I think is a target to make sure that freedoms of some people, majorly freedom of media, is suppressed, which I think is coming in bad faith for our country. And at the same time, Right Honorable Speaker, as I summarize, I believe this motion comes and calls for equal participation of all political parties in this country, because when all parties participate freely, it brings good governance to a country. Thank you, Right Honorable Speaker.
Honorable Tumuzigu, then Honorable Amede, Otieno, then Abala. 2 minutes each.
Thank you, Madam Speaker. I wish to thank my colleague, Honorable Kamba, for bringing this motion at this moment when we are coming from primary elections here in Uganda, NRM party and even other parties. But I wish to note, Madam Speaker, that though we have not gone far in democracy in Uganda, we need to celebrate the level we have reached so far in democracy here in the country. And again, I wish to urge each and every Ugandan to look at democracy as a very important issue in governance and even other sectors of any nation. We need to note that we've been backsliding, because when you consider the primary elections of these parties, and most especially NRM, it hasn't been simple, and therefore we need to think about how we can improve our democracy. We need also to note that democracy is very important as far as economic progress is concerned. If nationals are comfortable with their leadership, they do much to make sure that they produce. But when they are not sure of what is coming next, It is not simple. And it is important to note that even the foreign investors find a democratic country very good to settle in. So if democracy is not good enough, we are not likely to get enough foreign investors, and therefore our economies and our economy will suffer. It is not only here in Uganda, it is in most countries in Africa, and we need to really change the way we are living politically, such that this concept of democracy.
Thank you. Honorable Amede. Amede followed by Honorable Tieno, then Honorable Abala.
Thank you, Right Honorable Speaker, for the opportunity, and I thank Honorable Kamba for the motion. It is very important that this report has been brought on the floor of Parliament. Democracy is the backbone of progress of any society. Particularly, there is a relationship between democracy and the type of development or service delivery. Democracy defines the power structures and power relations and responsibilities of any given society therein. For example, good governance defines the social contract of the leaders and those that should be led. This motion should cause us, all of us leaders here, to reflect where we are in democracy in our country and where we want to go. The silent issues of use of money in our politics, the violence in our politics shouldn't define our politics in Uganda. Breaking it down to the experience of MP, I urge all of us stakeholders and government in particular to do civic education, because many of the masses are not so much abreast of why the elections of the MP. Honorable colleagues, I'm aware, you know how the roles of MPs have been distorted.
Honorable Otieno, then Abala, then Bamukwasa, Yinji, Lubogo. We need to close.
Thank you, Right Honourable Speaker, for this opportunity, and I also join my colleagues to thank Honourable Kamba for bringing up this motion. Right Honourable Speaker, it is I want to join my colleagues to first of all appreciate the motion. For Madam Speaker, when we are talking about democracy, I agree that it is a universally cherished value which is based on the free will of the people. Madam Speaker, the commemoration of the Democracy Day comes at a time when Ugandans have just gone through a party primary. It could have been a primary issue, an issue of one of the political actors, but this is a party which is in a government. And Madam Speaker, the lessons that we learn from these party primaries should help the country in improving our democratic principles. I appreciate that Uganda has traveled a long way in improving its political landscape. There are lots of things that have changed. A lot of democratic principles have been adopted, and we have moved on a long way. But Madam Speaker, we still have a lot of contradictions that still prevail and may negate all the gains that we have achieved so far. Some of the contradictions that we still have, that we witnessed very glaringly during the NRM primaries are issues to do with unleveled grounds, election rigging, and monetization of our democratic process in the country. Madam Speaker, if these principal democratic tenets are not addressed, then all the gains that we have achieved in our political landscapes.
Thank you. Thank you, Honorable Babara. Babara Bamkwasa. Chinjiru Wagomu Juke na Claude Senyo.
Yeah, thanks so much, Madam Speaker. Madam Speaker, I want to thank my colleague, Honorable Akamba, for this wonderful motion. Now, Madam Speaker, as we all know, democracy is not starting today. It has been there, and different countries have fought. They have tried to defend and protect the rights and the principles of democracy. Now, but when we come to Uganda, in our mother country here, and when we look at, when we talk about democracy, I just want to inquire whether the basic principles of democracy that we are talking about, whether now they resemble the real image of democracy, where it is something else that we're talking about. Number two, Madam Speaker, it is very true that when we talk about democracy, we are talking about the protection of the rights of people. We are talking about the participation. We are talking about the involvement. We are talking about good governance. The question is, this motion here is helping us to self-examine ourselves as Ugandans, whether we are following those basic principles of democracy, like freedom of speech. And you look at, for example, like recently we had the elections. I remember we talked about even the second elections. We were talking about even the NRM elections. We saw the reality, not only NRM, including FDC, because at least I'm sure when we were in order there, you saw what was going on even in FDC. Madam Speaker, I want to say this motion has come at a time whereby we as a country must examine ourselves properly, so that we address the hiccups, the challenges that we are going through as a country in promoting democracy in Uganda. I want to thank you so much, Madam Speaker, as we conclude by saying the democratic organization is the one that controls all the resources. And one thing that I am sure, the use of resources in this country.
Honorable 2 minutes, then Honorable Chinji, followed by Honorable Bogomu Juke, who closes with Senyonga.
Thank you very much, Right Honorable Speaker, for the opportunity. I want to add my voice to thank Honorable Akamba for the observance of remembering to move this motion to this House. However, democracy and freedom and democratic elections are indeed what everyone desires in the whole world. But Right Honorable Speaker, since multi-party dispensation, Uganda has never been in such an election, because in Uganda we just have elections under forced surveillance and high technical elections that are falsified. Therefore, on this day of commemorating the International Democracy Day, Right Honorable Speaker, I want to call upon and encourage our independent electoral commission to follow the real democracy and its values, not just to say it and read it on paper, especially in this era we are in of the COVID-19, to allow everybody democracy and freedom as we go for the general elections in 2021. I thank you so much, Right Honorable Speaker.
Honorable Dewo Chinji, then followed by Honorable Bogo.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, I want to thank my colleague, Honorable Kamba, for tabling this motion about democracy, celebrating democracy. Celebrating democracy today. But, Madam Speaker, I'm in a state of confusion. contrary to what other members have just alluded to, I think we should not be celebrating right now. If it was possible for us to postpone this celebration, I would be very happy. Why? Madam Speaker, right now, some of our people are still suffering because of the coronavirus. There are some districts which are not moving freely. They are still under a lockdown because of this coronavirus. Some people have even failed to reach polling stations to exercise their rights of voting and choosing their own leaders. So, Madam Speaker, I think when we say that we are participating in the celebration at this right time, I think we may not be in the right position to do that under the current circumstances. Madam Speaker, whereas some people are participating and they are exercising their democracy by doing their businesses, some places of worship are still closed down, schools are not working, because we cannot talk about democracy when we are basing it on elections that this just concluded the primary in the elections. They have not seen democracy at all. But we cannot say
Honorable Bogo, now just for clarity, honorable members, this is an international day pronounced by the United Nations 2007, and each country is required to commemorate it. That's what we are doing today. Honorable Bogo and then Honorable Mujuke.
Thank you very much, Right Honourable Speaker. Right Honourable Speaker, I rise to support the motion as presented by Honourable Kamba. Right Honourable Speaker, as we commemorate this day, I have tried to think about the day it was adopted. That was in 2007, and Uganda in 2006 had gone multi-party. So you can say that the day itself, the commemoration of the day and its recognition is as old as the multi-party in Uganda since 2006. Right Honourable Speaker, National Objective 2 of our Constitution talks about democratic principles that should empower and encourage active participation of all, not stifle and emasculate the participation of others. So I think while we are actually commemorating the day, we must reflect on the journey we have taken from 2006 when we went multi-party, or 2007 when the day was recognized. Right now, Speaker, the recent history of a few days ago reflects the kind of state we are at as a country. That has been a concern for everybody, including the head of state, that we have seen viciousness in this country that does not really reflect or show advancement of democracy. We have seen people dying, people being killed during elections of internal party elections. We have seen people dying. We have seen battery. We have seen bloodshed. And I think this is not really quite a good reflection on the journey that we are taking. So as a country, I think we have a long way to go. There's a lot of sensitization that.
Thank you, Honorable Mujuke. Then finally, Honorable Senyonga.
Thank you so much, Right Honourable Speaker. I stand to support the motion as a Democrat. Right Honourable Speaker, as we celebrate, as we reflect, we need to ask ourselves questions. Can we have democracy where there is no justice? Can we have democracy where there is no equal opportunities? can we have democracy where there is no fairness? Because if we are talking about democracy, we must talk about fairness, we must talk about equal opportunities, we must talk about justice. And therefore, as a country that yearns for democracy, this parliament is best placed to help Ugandans. Otherwise, we see a lot happening, right, Honourable Speaker, that institutions that are supposed to help this country to continue to democratize are being fused with the state. You find institutions like police being partisan. You saw the RDCs working for some candidates and not the others. You saw, so once this is still happening and we don't continue to condemn it, we'll be moving backwards. However, I want to support the motion and take this opportunity to condemn whatever institutions and individuals are working towards taking Uganda backwards and asking Parliament that we work together to promote democracy. Thank you very much.
Thank you. Honourable Sanyonga.
Thank you, Honourable Speaker and Honourable colleagues. I want to support the motion and also congratulate our country, Uganda, be part of the entire world as we celebrate democracy. As a developing country, Right Honourable Speaker and Honourable colleagues, we are still having some ups and downs, but I must agree that that's the way to grow. There is no way we are going to avoid such, because when you see 207 and this is 220, only 13 years, I have hope that we, if we the players plus other actors can practice fairness, we shall have democracy enjoyed by many. But even if we the players are still complaining against each other, there's no way we are going to complain and say there's no democracy. Therefore, I support the motion that as a growing country, we shall overcome whatever is ahead of us. We should learn and lead by example. I thank you, and I totally support the motion.
Thank you very much, honourable members. I put the question that the question be put. Those in favour say aye, the contrary no. So I put the question that this House do adopt the proposal in the motion. Those in favour say aye, the contrary no. Honourable members, let a tribute, the resolution be extracted and together with the Hansard to be sent to the headquarters of the Interparliamentary Union in Geneva. Thank you very much. Let's go back to item 11.
Item number 11, Bill second reading, the Labour Disputes, Arbitration and Settlement Amendment Bill 2019.
Understand the Minister now has the issues which were raised on the floor. Honourable Tumweba.
Right Honourable Speaker and Honourable colleagues, I have managed to capture from the answer of the day, there were just like two issues, one raised by Honourable Jonathan Odur, who was concerned that the appointment of judges to the industrial court was settled, would first of all limit their professional development, because they would be full-time at the court and they would not be transferred to other divisions to move around. But my response to him is that the issue of appointment of judges of the industrial court was settled by the Constitutional Court in Constitutional Petition number 33, where the Constitutional Court held that the industrial court is a subordinate court with concurrent jurisdiction. Therefore, the appointment is specific to the industrial court. The judges of the industrial court cannot be transferred, but can be promoted. So an appointment, definitely they can advance their professional career. Then the other concern we noted that the administration of the Judicial Act did not make reference to the judges of the Industrial Court, so we have accordingly proposed an amendment to specify that the terms and conditions of the judges of the Industrial Court will enjoy benefits similar to those of other judges as provided in the administration of the Judicial Act. So he was concerned with the need to cross-reference. Yes, we can do that. I guess the lawyers will be able to sort that. Honorable Yomoch, Madam Speaker, was also concerned on the backlog, but the amendment which proposes to increase the number of panelists to 20 members from 5 will solve the concern he was raising. Madam Speaker, those were the sticky issues that ensued in the limited debate I saw on the Hansard. I beg to submit. Thank you.
Thank you very much, members. I now put the question that the bill be read for a second time. Those in favor say aye, the contrary no. Those in favor say aye, the contrary no.
Bills Committee stage, the Labour Disputes Arbitration and Settlement Amendment Bill 2019. Clause 1.
The members, I put the question that clause 1 do stand part of the bill. Put the question that clause 1 do stand part of the bill. Those in favor say aye, the contrary no. I serve it.
Clause 2.
Put the question, clause 2 do stand part of the bill. Those in favor say aye, the contrary no. Those in favor say aye, the contrary no. Huh? So an amendment?
There is amendment, Madam Chair.
On clause 2?
Thank you. Clause 2, amendment of section 7 of the Principal Act. Clause 2 is substituted for the following. Amendment of section 7 of the Principal Act. The Principal Act is amended by inserting immediately after section 7 the following. 7A, official seal. The Industrial Court shall have a seal which shall be judicially noticed. 2, the head of judge shall be the custodian of the seal of Industrial Court. Madam Speaker, Madam Chair, would like to make a correction on the title of the Chief Judge. The title is Head Judge. That is a correction. The Judicial Court may A, assign the custody of the seal or a duplicate of it to the judge or registrar of Industrial Court. B, give the records subject to this section as to the manner in which the seal shall be kept and used. 3, nothing in this section shall affect the validity of any document lawfully sealed before coming into force of this act. Justification. 1, to conform the clause to the provisions of section 42 of the Judicature Act. Cap 13, which provides for the seals of the Supreme Court, Court of Appeal, and High Court. 2, to expressly give the responsibility of the custody of the seal to the head judge as it is for other courts.
Honourable members, you have heard the proposal. I put the question that clause 2 be amended as proposed. Those in favour say aye, the contrary no.
Clause 2 as amended.
Question is that clause 2 as amended do stand part of the bill. Those in favour say aye, the contrary no.
Clause 3.
Put the question that clause 3 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 4.
Clause 4, Honourable Chair, I think we have an amendment.
Clause 4, amendment of section 10 of the Principal Act. Clause 4 is amended in the proposed section 10A, subsection 1, by deleting paragraph B. 2, paragraph C, by substituting for the word 3 with the word 4. B, by substituting for section 2 the following. 2, the head judge and the judges of the industrial court shall be appointed by the President on the advice of the Judicial Service Commission with the approval of Parliament. C, by inserting immediately after subsection 4 the following. Number 5, the members of the industrial court, other than the judges, shall hold office for the term of 5 years and shall be eligible for reappointment. Justification. Bullet 1, subsection 1B is to align the industrial court with the hierarchy in other courts. 2, subsection 2 is to align the provision with Article 142(1) of the Constitution that provides for the approval of the judges appointed by Parliament. Subsection 5 is to utilize the expertise and knowledge of the members, considering the limited number of people with qualifications and experience in labor sector. Submit. I beg to submit.
Members, you have heard the proposals. I put the question that clause 4 be amended as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 4 as amended.
Question is that clause 4 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 5.
Clause 5, Honourable Chair.
Madam Chair, we seek to insert paragraph A, seeking to 10A, 10B, and 10C in the Principal Act. We seek to insert paragraph A, seeking to amend the proposed section 10. Clause 5. In the proposed section 10A, 1, subsection 2, by deleting the phrase "and shall be subject to the Judiciary Service Commission." 2, by substituting for subsection 3 the following. On 3, where A, the office of the judge of the industrial court is vacant. B, a judge of the industrial court is for any reason unable to perform the functions of his or her office. Or C, the head judge advises the Judiciary Service Commission that the state of business in the industrial court so requires. The President may, acting on the advice of the Judicial Service Commission, appoint a person qualified for appointment as a judge of industrial court to act as a judge even though that person has attained the age prescribed for retirement in respect of that office. 3, by inserting immediately after subsection 3 the following. 4, a person appointed under subsection 3 to act as a judge of the industrial court shall continue to act for the period of the appointment, or if no period is specified, until the appointment is revoked by the President acting on the advice of the Judicial Service Commission, whichever is earlier. Justification. The new subsection 3 is to provide for procedure of removal and appointment of a judge in the interim in case of vacancy arising under any of the circumstances mentioned. 2, harmonize the operations of industrial court with those of other courts of judicature and to ensure continuity for administration of justice. Under subsection 4, provides the procedure of removal of the judges appointed in the interim. Madam Speaker, we also seek, Madam Chair, we seek to correct what was named paragraph A to be paragraph B in the proposed section 10B. 1, by substituting for section 3 the following. 3, notwithstanding subsection 1, where at any time before a matter is determined, the industrial court is constituted and one of the members ceases to be a member or is not available to attend the proceedings. A, if the member is not the judge, the presiding judge, in consultation with the head judge, shall have power to co-opt another member of the industrial court to hear the matter until it is determined. Or B, if the member is the judge, the head judge shall assign another judge of the industrial court to preside over the hearing of that particular matter until it is determined. 2, Roman 2, by deleting subsection 4. Justification. Subsection 3 is to ensure speedy resolution of labor disputes and to maintain the tripartite nature of the court, which would be hampered if the matter proceeded without any of the required persons. Subsection 4 is redundant since the provisions are encompassed under subclause 2. We also seek to amend paragraph B in the amendments to read C in the proposed section 10C. 1, subsection 2, by inserting the words giving 30 working days between the words by and not. Justification. The period within which to give notice is important to give the minister ample time to replace the member through the procedure set out by law. I beg to submit.
Honourable members, you have heard the proposal. Put the question that clause 5 be amended as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 5 as amended.
Question that clause 5 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 6.
Put the question that clause 6 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 7.
Honourable Chair, I think you have some amendments.
Madam Chair, Clause 7, amendment of Section 18 of the Principal Act. Clause 7 is amended in the proposed Section 12. 1. In Section 1, by deleting the phrase "who shall be appointed by the Judicial Service Commission." 2. By inserting immediately after subsection 1 the following 2 subsections. 2. The registrar shall be appointed by the President on advice of the Judicial Service Commission and shall be disciplined and removed from office in accordance with Article 147 of the Constitution. 3. The Deputy Registrar and Assistant Registrar shall be appointed, disciplined and removed from office by the Judicial Service Commission in accordance with Article 148A of the Constitution. 3. Roman 3, by deleting subsection 5. Justification. To conform the provisions of Article 145(2) of the Constitution, which mentioned the appointing authority for the registrar as the President on advice of the Judicial Service Commission. To align the provisions which Article 145A of the Constitution. I beg to submit.
Honourable members, you have heard the proposal, so clause 7, I put the question that clause 7 be amended as proposed. Those in favor say aye, the contrary no.
Clause 7 as amended.
Question is that clause 7 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 8.
Put the question that clause 8 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 9.
Put the question that clause 9 do, I think have some, clause 9, double check.
Madam Chair, Clause 9, amendment of Section 14 of the Principal Act. Clause 9 is amended by, in the proposed Section 14, deleting subsection 5, Roman 2, deleting subsection 6. Justification, subsection 5 is not necessary since this power is enshrined in the power of the court to make binding decisions and orders. 2, subsection 6 is against the principle of corporate governance for the court to descend in the arena of the operations of the corporate bodies.
Honourable members, in relation to clause 9, those are the proposals. I put the question that clause 9 be amended as proposed. Those in favor say aye, the contrary no.
Clause 9 as amended.
Question is that clause 9 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 10.
Put the question that clause 10 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 11.
Clause 11. Yes, Honourable Minister.
Madam Chair, we have an amendment to move there in consultation with the Chair. We are in agreement, and also to respond to the concerns of the members. We are moving an amendment on clause 11, which seeks to amend the Principal Act is amended by substituting section 41 of the following. 41, remuneration, allowances and other expenses. 1, the remuneration, emoluments and benefits payable to the head judge, deputy head judge and other judges and registrars of the industrial court shall be the same as those payable to the judges and registrars of the High Court as provided under the administration of the Judicial Act 2020. 2, Madam Chair, the calculation of benefits under subsection 1 shall take into account the period of service of such judge or registrar in the same way as under the administration of the Judicial Act. Justification, Madam Chair, it is to put the judges and registrars of the industrial court at the same level with those of the High Court, thereby encouraging judicial officers of long experience and high rank to join and serve the industrial court without fear of lesser benefits. I beg to move.
Now, members, in relation to clause 11, you've heard the proposals. I put the question that clause 11 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 11 as amended.
There are other clauses in the bill that should remain.
I think I just addressed the proposals. I don't think, we are not deleting clause 11.
The proposal.
Yes.
As the chair prepares to make a submission, whereas I agree with the amendment proposed by the minister, I find the second part of it redundant, because already in the first part of it we are saying the remuneration, emoluments and benefits are payable in accordance with the other law. So we do not need again the other one, because the benefits are already catered for. How you calculate and arrive at it is already catered for another law. So I think that second bit of that amendment is actually redundant, and we can do away with it. That's why.
No, I think there was a clause including retirement benefits. I think they added that. I think they added the word including retirement benefits.
Yeah, Madam Chair, you are perfectly right, because the particular act we passed is in respect of retirement benefits only. and yet the appointment of judges and registrars and their remuneration is covered under other provisions. So the proposed amendment by the minister captures the spirit of covering these particular officers, and I beg my honorable colleague from Tororo to abandon his objection.
Honourable members, I put the question that clause 11 as amended do stand part of the bill. Those in favour say aye, the contrary no.
Clause 11 as amended.
Madam Chair, I think we got mixed up. We had prepared a clear amendment, but we have harmonized with the ministry. I would request that you allow me to read the amendments that we had prepared, and we see how to move. On clause 11. Thank you. Clause 11 as amended. In the proposed subsection 1, insert the words including retirement benefits immediately after the word benefits, and delete the words deputy head judge. 2, Roman 2. In the proposed subsection 2, substitute for the word judges the word staff of the judiciary. Roman 3, replace the proposed subsection 3 with the following. 3, the remuneration, emoluments and benefits, including retirement benefits, payable to the registrars, deputy registrar and his assistant registrar shall be the same as that payable to the registrars of equivalent rank in the High Court. Roman 4, insert a new subsection immediately after subsection 5 as follows. 6, the head judge, registrar, deputy registrar, and assistant registrar of industrial court shall be deemed to be staff of the judiciary and shall be entitled to the retirement benefits and other benefits applicable to such a staff of the judiciary under the administration of the Judiciary Act 2020. Justification: to align the provisions of the Act to the recently enacted administration of the Judiciary Act 2020, which among others provides for retirement benefits and of judicial officers. I beg to submit.
Now, what do we do now with the minister's amendment?
Madam Chair, when you look at that provision, I just need to be helped. They talk about head judge. I don't know. I need to be helped in this case because I am not a lawyer. I need to be helped. Who is a head judge in this case, in terms of industrial court? So I need to be helped. Are we talking about the chief judge? Is who? Okay, police information.
Thank you, Honorable, for giving way. The information I want to add you is that when we're passing the other law, is it the emolument, the benefits of the judges, we catered for the principal judge as the head of the court, and his benefits are different from the other judges. Now here we're also having head of a court. So what I need, the information we need to clarify here is, does this put this head judge at the level of a principal judge? Because it needs to be very clear. Because you may be cheating this head judge when it comes to calculating his emolument, because he's also head of a court. A principal judge is also head of a court, and this one is also head of a court. So we need to be clear. What is this head judge? Is he at the level of a principal judge, so that we know his benefits are known, and not going again to Constitutional Court to interpret? Thank you.
Yeah, thanks so much, my friend. Now, Madam Chair, need to be, that is the clarification, because we're in a real jam if we don't address this matter. Because I was talking a head judge, a principal judge. In this case, what are we referring to? Are we talking about a principal judge? Are we talking about a head judge? Who is this head judge? And which law is it operating? That's what we need to be helped. So, thanks so much.
Honourable members, the head judge is the head of the industrial court. The industrial court is different from the high court and the court of appeal. It is under the Ministry of Labour. So the head judge is the head of that court. Yes.
Madam Speaker, the amendment from the chair captures the spirit of my previous amendment. So I concede to a larger extent, and I only beg to make a slight amendment with the concurrence of the chair, where she says, insert a new subsection immediately after section 5 as follows. The head judge, judge, registrar, deputy registrar, and assistant registrar of the industrial court shall be deemed to be staff of the judiciary, and that should be deleted because they are not. That should be deleted because they are not. Otherwise, the entire amendment, the chair moved proceeding after mine, stands with that amendment.
So you want the words shall be deemed to be staff of the judiciary removed?
Removed, Madam,
So
Madam Chair.
After industrial court, we say shall be entitled.
Yes.
Is that okay, Chair?
That's okay. Yes, Madam Chair.
Okay. Honourable members, I put the question that clause 11.
Madam Chair, need to be held because somewhere saying there shall be as those. Now the question is, are we using mathematics to say if because you are heading here, so you must also be equal to the other one? I need to be helped here because this bit here it's a bit challenging. I need a minister and then a chairperson, the chair, to clarify this matter because this matter is not very clear to me and other people, other colleagues who are here.
Madam Chair, I think you had put it clear. The head judge is an administrative head judge of the industrial court. He or she, they are judges. They are equal. They are not equal to the principal judge, but they are also judges. But at the industrial court, they are administrative heads. Thank you.
Okay. Honourable members, I put the question that the word shall be deemed to be staff of the judiciary and shall be deleted and shall be entitled. I'm just trying to remove the words which are offending. So if we could remove those words shall be deemed to be staff of the judiciary and just remove shall be entitled to the retirement benefits and other benefits applicable. We delete that and then we take the proposal. I put the question that clause 11 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 11 as amended.
Question is that clause 11 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 12.
Put the question that clause 12 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
The title.
Members, I put the question that the title do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Motion for the House to resume.
Honourable Minister.
Madam Chairperson, I beg to move that the House do resume and the Committee of the whole House report thereto.
Honourable members, the question is that the House do resume and the Committee of the whole House do report thereto. Those in favor say aye, the contrary no.
Reports of the Committee of the whole House.
No, Minister.
Right Honorable Speaker, I beg to report that the Committee of the whole House has considered the bill entitled the Labor Disputes Arbitration and Settlement Amendment Bill 2019 and passed and pass it with the relevant amendments. I beg to submit.
Motion for adoption.
Motion for adoption of the report from the Committee of the Whole House.
Right Honorable Speaker, I beg to move that the report from the Committee of the Whole House be adopted.
Now, members, the question is that the report of the Committee of the Whole House be adopted. Those in favor say aye, the contrary no. Ayes have it.
Bill third reading.
Honourable Minister.
Right Honorable Speaker, I beg to move that the bill entitled the Labour Disputes, Arbitration and Settlement Amendment Bill 2019 be read the third time and do pass.
Honourable members, the question is that the Labour Disputes, Arbitration and Settlement Amendment Bill 2019 be read the third time and do pass. Those in favor say aye, the contrary no. Ayes have it.
A bill for an act entitled the Labour Disputes, Arbitration and Settlement Amendment Act 2020.
Title settled and bill passes.
Item number 12, bill second reading. The National Social Security Fund Amendment Bill 2019.
Right Honorable Speaker, I move that the NSSF Amendment Bill be read for the second time.
Is it seconded? Is it seconded? Justification? Justification for the second reading.
Right Honorable Speaker and honorable members, I have the honor to undertake the second reading of the National Security Amendment Bill. The National Social Security Fund Amendment Bill 2019 was sponsored by the Ministry of Gender, Labour and Social Development to address the following prevailing challenges registered under the current law. The current law was enacted in 1985 and does not adequately address emerging challenges in the management of social security in Uganda. The current law limits the ability of the NSSF to extend coverage to all workers. It does not provide for the flexibility to introduce new benefits, yet changing circumstances may require that benefits be introduced. Under the current law, Madam Speaker and honorable members, workers' contributions and the NSSF income are taxed while the workers' benefits are not taxed. This system is like taxing the seed and not the harvest. Taxing workers' contributions discourages long-term saving by workers and also reduces the amount of revenue collected by government from NSSF. The current law does not specify stakeholder representation, especially the workers and employers, as required by the International Labour Convention 102 on Social Security. The penalties for non-compliance in the current law are as low as 10,000 shillings. The appointment of the managing director and deputy managing director by the minister without the role of the board undermines the ability of the board to supervise them. Currently, only workers in a company that employs 5 or more employees are eligible to contribute to their retirement, which contradicts paragraph 7 of the national objectives of the directive principles of state policy under the Constitution and the ILO Convention 102 on Social Security and the Social Protection Policy 2015, which all call for social security coverage of all persons regardless of the number of the employees. The Act does not make provision for a window for limited expenditure prior to approval of the annual budget by the minister. Besides, despite the high cost of private fund managers, Section 33 of the Uganda Retirement Benefits Regulatory Authority Act 2011 requires that all funds of the retirement benefit scheme should be invested through a private fee charging fund manager, yet some of the investments like the buying and selling of government securities can be done more cost-effectively in-house by National Social Security Fund. In addition, Madam Speaker, whereas the filing of annual returns by employers is important for purposes of monitoring workers' contributions, failure to do so is not an offense under the Act. The Right Honourable Speaker of Parliament and honourable members, the NSSF Amendment Bill 2019, therefore, seeks to address the gaps highlighted through 1. Streamlining the appointment of the board and staff of the fund, including its governance, extending the coverage of the fund to all workers regardless of the size of their enterprise, including voluntary contribution by workers and self-employed persons. 3. Providing for midterm access of voluntary benefits on such terms and conditions that may be set by the board. 4. Increasing the fines for offenses under the Act. 5. Providing for tax measures for exempting workers' contributions and scheme income from taxation. 6. Empowering the minister to prescribe a threshold of expenditure by the fund prior to approval of the annual budget by statutory instrument. 7. Empowering the board to use in-house expertise and fund managers in the investment of scheme funds, including lending to government. 8. Empowering the board to introduce new benefits in consultation with the minister. And 9. Providing for payment of annual levy by the fund to the Uganda Retirement Benefits Regulatory Authority. 4. Right Honourable Speaker of Parliament and honourable members of Parliament, I wish to restate that the bill, in view of what is stated above, is necessary, and therefore pray that Parliament concurs with my observations and approve the bill for enactment into law. I beg to, Madam Speaker.
Shall we have our chair a report?
Thank you, Right Honourable Speaker. Madam Speaker and honourable members, I would like to bring to your notice that there are 2 minority reports attached to the major report. One is by Honourable Akol Anthony and Honourable Nandala Mafabi. The second one is by Honourable Kenneth Lubogo. I beg that the House will allow the 2 to read their reports. Thank you.
Present your report. After that, then the others will come.
Thank you, Right Honourable Speaker. This is a report. This is a joint committee report of the Committee of Gender, Labour and Social Development, and Finance, Planning and Economic Development on the National Social Security Fund Amendment Bill 2019. Madam Speaker, the National Security Fund Amendment Bill 2019, herein referred to as the bill, was read for the first time on 13th August 2019 and referred to the Committee of Gender, Labour and Social Development for consideration in accordance with Rule 128 of the Rules of Procedure of Parliament. Following the request from the Minister of Finance, Planning and Economic Development, the Speaker later on instructed the Committee of Finance, Planning and Economic Development to join the Committee of Gender, Labour and Social Development in the coming up with the final report on the bill. The joint committee considered the bill and now reports. The background. The current law, the National Social Security Fund, NSSF Act Cap 22, was enacted in 1985. Over the course of 35 years since its enactment, Uganda's economy and pension sector has evolved faster than had been envisioned in the Principal Act, thus requiring changes in how the fund is managed and to improve its relevancy to the serving workers and the economy as a whole. Policy and principles of the bill. The policy behind the bill is to expand Social Security coverage by making contribution to National Social Security Fund mandatory for all workers in the formal sector, and also allowing workers in the formal and informal sectors to make voluntary contribution to the fund. In addition, the bill seeks to enhance the spectrum of benefits available to workers and to improve management of the National Social Security Fund. The methodology. The Joint Committee held consultative meetings.
I think those you can leave. Members can read that.
Okay.
Even the
4.1, the meetings, members will read for themselves. We did documentary review, study vis. I will have to read on the study vis because we had some best practices there. The Joint Committee undertook a study vis from 20th to 25th October 2019 to Ghana to benchmark on the National Social Security Fund Amendment Bill 2019. The expected outcome of the benchmark was a better understanding of the process undertaken in conducting reforms to the retirement benefit sector, the stakeholders involved in the process of reforms and the roles of each one of them, plays, and the general impact of the reforms on the sector and the economy. Reforms in the pension sector in Ghana. In 2004, the process of reform of the pension sector in Ghana commenced with the appointment of the Presidential Commission on Pensions, whose mandate was to study the pension sector in Ghana, make comparisons with international best practices, and come up with recommendations for reforms. The Commission studied the pension sector and came up with the following recommendations. Set up a three-tier unified contributory pension structure comprising 2 mandatory schemes and a voluntary scheme which would cover both the private and public sector workers as well as those who may be self-employed. 2, establish a regulator to oversee the administration and management of pension funds and service providers in the pension sector in Ghana. The recommendations of the Presidential Commission in the pensions were executed through legislative reforms under the National Pensions Act 208, Act 766, that saw the introduction of tied pension system, the restructuring of Social Security, and the National Insurance Trust. To ensure it was the national mandatory scheme and the creation of pensions regulator to ensure the realization and implementation of unified pensions regime. Tax incentives. As the incentive to encourage savings which would ensure affordability, the reforms introduced tax incentives both in the formal and informal sector in Ghana. The tax application to pension schemes is therefore total exemption. That is EEE. Exempt. Where contributions are exempted, the scheme income is exempted and the benefits are all exempted of taxes. Applications of relations from Ghana to Uganda. As earlier noted, the pillars for reform of the Ghanaian pension sector were predominantly improve /extend coverage to ensure adequacy of benefits and ensure sustainability of pensions. The Joint Committee therefore observed that these pillars resonate with the objectives of the National Social Security Fund Amendment Bill 2019. From the lessons learned from Ghana, the Joint Committee recommends the following to be incorporated in the bill where possible or considered by the government as the case may be. 1, coverage. The formal and informal sectors should be covered by the Social Security Scheme. Roman 2, NSSF should be permitted to support the national objective that provide for expand the other pillars of Social Security, including health and employment. Roman 3, benefits of members, including health benefits and employment benefits, among others, should be enhanced through voluntary contributions over and above their mandatory contribution. Tax incentives must be provided for that will act as incentives to encourage long-term savings. B, products. 1, benefits arising from the contribution should be permitted to be utilized as collateral for mortgage, finance for residential housing. Section 68 of the Uganda Retirement Regulatory Authority Act 2011 permits benefits to be utilized as collateral for mortgage finance. C, minister responsible for the Social Security. 1, the responsible minister for Social Security and National Insurance Trust SSNIT in the ministry responsible for labor is the minister responsible for labor. General observations. 5.1, compliance of NSSF Act Cap 222 with the provisions of the Constitution of the Republic of Uganda. The Joint Committee observed that the principles of NSSF Act Cap 22 covers only the mandatory contribution in the formal sector, excluding voluntary contribution, both in formal and informal sector. There was therefore need to amend the law to give the workers access to Social Security no matter the number of employees in the organization, both formal and informal. 5.2, compliance with UN 2030 Agenda for Sustainable Development. The Sustainable Development Goals are universal. Call to action to end poverty, protect the planet, improve the lives of prospects everyone, everywhere. The Joint Committee observed that if the country is to achieve the goals under the UN 2030 Agenda for Sustainable Development, a reform of the pension sector is inevitable. The Joint Committee observed that NSSF Amendment Bill 2019 is compliant with UN 2030 Agenda for Sustainable Development, especially in the areas of poverty alleviation and social security, but should be strengthened to support the provision of expansion of other social security pillars like health and employment. Compliance with the principles of gender and equity. I will leave that one out, Right Honorable Speaker, for members to read for themselves. 6.0, specific observations and recommendation of the committee. The Joint Committee observed 6.1, Clause 2, supervision of NSSF. The Joint Committee observed that in 204, His Excellency the President of Uganda had transferred the supervision of NSSF from Ministry responsible for Social Security to the Ministry responsible for Finance. Consequently, during the consideration of the bill, His Excellency the President wrote to the Speaker of Parliament requesting that the oversight role over NSSF be streamlined and placed under the Ministry responsible for Finance. The two Ministers of Labour and Finance met the Joint Committee and reaffirmed the decision of His Excellency the President. Having received the President's directives after the bill's first reading, the Right Honourable Speaker advised that Ministers responsible for Labour and Finance be present during consideration of the bill and its second reading to ensure that the directive of the President is captured in the amendment. Notwithstanding the above, the Joint Committee observed that the roles of two ministers responsible for social protection and finance are separated in the bill and in line with their sector-specific mandate. It was further noted that it is not novel for the legislation to share responsibility among several ministers. After all, the Ministry of Public Service is also mandated under Section 17 of NSSF Act to specify public employees for whom the Treasurer may make payments to the fund. Reference was made to Ghana, where both ministers responsible for Social Security and Finance serve different roles in Social Security. The Joint Committee recommends that the status quo remains whereby the fund is supervised by both the Ministry responsible for Finance and the Ministry responsible for Gender, Labour and Social Development. 6.2, Clause 10, midterm access and to voluntary benefits. The Joint Committee noted that the purpose of midterm access is to provide for additional benefits and relief to members of the fund before they reach the age prescribed by the law for accessing their full benefits. The Joint Committee further observed that the bill only covers voluntary contribution and should therefore be amended to apply to all contributing members of the fund, including mandatory contribution. This is because benefits are primarily intended to better the lives of all members of the fund. The Joint Committee recommends that where the member has not exercised the above benefit, the member may access mid-term benefit of up to 20% of accumulated contributions, including mandatory savings, be allowed upon application. The beneficiary must have saved for 10 years and attained the age of 45 years. A person with disability who lacks gainful employment or fails to generate income and unable to make contribution to the fund for the period of not less than 1 year should access up to 75% of their contribution upon application, subject to approval from the minister. 6.3, Clause 12, lending to government directly. The Joint Committee observed that the bill seeks to authorize the fund to lend directly to government. The Joint Committee observed that this contravenes Section 68 of the OBRA Act 2011, which prohibits direct lending which is not through securities sold to the open market. This is intended to avoid abuse of members' funds and to avoid conflict of interest. The Joint Committee further noted that NSSF already lends to government and other entities using instruments prescribed in the OBRA Act and regulations. These include the treasury bills and bonds and government securities. The Joint Committee recommends that the authorization of the fund to lend directly to government be deleted from that bill. Additional amendments. Section 21 of the Principal Act, access to withdrawal benefits. The committee observed that only foreign members who have served for 4 years or more are entitled to withdraw benefits as provided under Section 21(2) of the Principal Act. For members who have served for less than 4 years, they are entitled only to their contribution to the fund, while the rest of the money is paid into reserve account. The Joint Committee observed that Section 21 of the Principal Act is unfair and disadvantageous to a member of the fund. The committee recommends the Principal Act be amended to allow for any member who have served with the fund to obtain full withdrawal of benefits at the end of the work permit period. 7.2, the Section 36 of the Principal Act, management of the reserve account. The committee observed that Section 36 of the reserve account to which particular fund shall be deposited, including fines and penalties, special contribution to the fund and investment income of the fund as the minister may, in consultation with the board, determine. The Joint Committee observed that special contribution that relate to the 10% employer contribution for expatriates who do not remit 5% of their monthly salary are retained by the fund as forming part of the income to the fund. Joint Committee recommends that special contribution should not be retained by NSSF in reserve account unless they cannot be allocated to account of members who had contributed to the fund. 2, publication of unallocated benefits in newspapers should be made mandatory to inform the concerned members so that he or she can claim their benefits. Conclusion. Uganda has had a successful recommendation of poverty reduction over the years. Poverty has steadily declined from 56% 1992 to 21% 2017. However, the level of vulnerability is still high and access to social services remains a challenge in the country. In the post-COVID-19 world, social security shall be a cardinal pillar in rebuilding the country's economy and shall help improve the livelihoods of Ugandan workers. The National Social Security Fund Bill 2019 shall enable the country in this quest for human development. Lastly, the Joint Committee received serious concerns regarding knowledge and awareness of laws regarding social security, including NSSF Act Cap 22. The public in general and workers in particular are unaware of their rights, benefits, privileges of savings, and thus are not motivated to be part of and parcel of the social security sector. The committee calls on government to intensify awareness of NSSF and related laws. I beg to move. Right Honorable Speaker, the minutes and details are hereby laid on table. Thank you.
You can lay the minutes. Lay the minutes, then we'll invite the minority reports. Let me invite Honorable Bogo, Minority Report. Is Honorable Anthony Okello here? Has he assigned anyone to this report?
Thank you very much, Honorable Speaker. And I appreciate my chair for recognizing my position as a minority on the minority report. But Honorable Speaker, this minority report is signed by my sole self, and it is in accordance with the Rule 02 of the Rules of Procedure. Honorable Speaker, I want to submit a dissenting position from the main report, being a position that was assailed at the committee level pertaining to mid-term access to social security upon loss of employment. I raised this matter in the committee and it did not succeed. But, Honorable Speaker, the right to life or right to live has been defined in several jurisdictions to include the right to access the basics of life, such as food, shelter, which make it possible to live, as was defined in the Indian case of Org and others versus Bombay Municipal Council, that the right to life encompasses the means to livelihood, i.e., that which makes it possible to live. Accordingly, it is my considered opinion, Right Honourable Speaker, that where a person who has contributed to Social Security Fund loses his or her job and remains unemployed for years and is unable to afford the basics of life, such as rent for shelter, food, education for one's children, etc., etc., such a person should have access to a fraction of his or her savings or the fund on his account. But, Honourable Speaker, our Constitution considers human life as sacred, and life should not be taken away from somebody, whether directly or indirectly. And I wish to opine that a denial of a person to access funds that belong to him or to her, when that member is in a situation where he or she cannot afford the basics of life, such as food, rent, clothing, such is a violation of the right of that person, the right to life of that person. Right, Honourable Speaker, it cannot be, and I think it could not have been the intention of Parliament, that one would rather receive one's social security saving when one has passed on, and therefore leave it for the beneficiaries or the survivors, than he himself, the laborer himself, receiving that payment. But even if that were the intention, Right Honourable Speaker, then I think this House should depart from it. I therefore, Right Honourable Speaker, implore the House, my colleagues, to consider this position seriously and adopt an amendment as I have proposed under. Right Honourable Speaker, according to the main report, there is an amendment which is listed as 24A, which include, which is to 24A, and it is my proposal that it should be renumbered by including a new 24A4 to state that where a member loses his or her employment and remains unemployed for a period of not less than 3 years. Such a member shall, upon application, be entitled to 40% of the balance on the member's account. The justification, Right Honourable Speaker, is to uphold the right to life by allowing the member or members who lose employment and remain unemployed for a long period of time and are in dire conditions to receive part of their social security and be able to sustain their life by affording themselves the basics that are needed in life. Right Honourable Speaker, I wish to submit and implore my colleagues to support this position because this money belongs to someone and this person has lost a job and time has passed and the person is suffering. And I don't see any reason why we should attach 45 years to that. If somebody is 35 years or 38 and has a family and he cannot sustain his family, but his money is there in Social Security, why would this person, first of all, be condemned, say to die, then the beneficiaries receive the money? I therefore implore my colleagues to receive my minority report with favor and support it. I thank you, Right Honourable Speaker.
Thank you very much, honourable members. The minority report has been noted. The amendment will be considered together with other amendments at the committee stage. Honourable Akol? Okay. Honourable someone standing in for Honourable Nandala and Honourable Akol.
Honourable Speaker, they also proceeded under Rule 194 and the areas of dissent from Honourable Nandala Mafabi, with the majority report of the committee regarding the recommendation to approve this bill with the amendments on the following areas. This is where they dissented. Supervision of NSSF. B, mid-term access to benefits. 3, taxing of benefits at time of withdrawal.
Where is the minister? Where is the Minister for Gender? No. Get member. Where is the minister?
So, Madam Speaker, on supervision of NSSF, Clause 12 to 18 of the bill proposes to replace the word minister in the Principal Act with the minister responsible for finance. It should be noted that the definition of the minister as provided for in the interpretation section 1, Clause U of the Principal Act has been maintained to mean the minister responsible for social security. In this case, the Minister of Gender, Labour and Social Development. This implies that NSSF will be supervised by 2 ministers, i.e. the Ministry of Finance, Planning and Community Development, and the Ministry of Gender, Labour and Social Development. We therefore propose that this provision be deleted so that the minister in charge of social security be left to take charge of NSSF. The ministry in charge of finance be represented on the NSSF board to cater for the interests of the Ministry of Finance, Planning and Community Development, putting the responsibility for implementing of NSSF Act under 2 ministries may cause conflict, confusion, and may result into failure to implement the law. 3.2, Madam Speaker, mid-term access to benefits. Right, Honourable Speaker, the bill restricts mid-term access to only voluntary contributions, hence it should be expanded to apply to all contributing members of the fund. While we agree that all contributing members should access mid-term payments, the period a member should have contributed to fund of 10 years and access of 20% of the accumulated saving is too low. This is because most of the members will not have contributed sufficient funds to allow profitable investment. Furthermore, Honourable Speaker, many of the contributors have suffered when they lose employment and spend long period of time without getting employed again. Under the current law, they cannot access their savings with NSSF. Also, in times of national disaster and pandemic like currently we are facing the COVID-19, some NSSF members have not been able to access their savings despite the suffering they are experiencing. We therefore recommend the following. A, mid-term access of 30% of accumulated contributions and interest to be allowed provided a beneficiary has worked for at least 15 years, attained the age of 45 years, whichever comes earlier. B, a beneficiary gets 10% of the accumulated contribution if she loses a job and remains unemployed for a period more than 5 consecutive years. C, a beneficiary gets 5% of the accumulated contribution if she is unable to support himself or herself when there is a national disaster or outbreak of pandemic lasting more than 6 months. 3, taxing of benefits at the time of withdrawal. Clause 19 of the bill proposes for substitution of Section 38 of the Principal Act by proposing to exempt the member contribution, employer contribution, and the investment income of the fund. Therefore, tax the member benefits at the time of payment except for death or invalidity. Taxation will be at the rate prevailing at the time of payment of benefit. This is premised on the fact that it will generate more income for the contributing member and government, resulting from increase in income arising from the delay in collecting tax. However, this has been made an assumption that there is constant return on investment over the period, which may not be the case due to the shocks that happen to the economy. It also does not take into account that the tax rates may rise in the future years and put the contributors at a disadvantage. Mr. Speaker, in addition, this provision violates Article 254(2) of the Constitution of the Republic of Uganda that provides as follows. I read verbatim. The pension paid to any person shall be exempt from tax and shall be subject to periodic review to take into account changes in the value of money. It also contravenes Section 21(1)(o) and (n) of the Income Tax Act that states the following amounts are exempted from tax. N, pension. O, a lump sum payment made by a resident retirement fund to a member of the fund. We therefore recommend that Clause 19 be deleted. Tax should be imposed on the investment income of the pension fund and not on the benefit paid out to a member. Right now, Speaker, in conclusion, I implore you to support the minority report I beg to submit, signed by Honorable Akol Anthony MP Kiraka North and Honorable Nandala Mafabi. I've just read for them. Thank you, Honorable Speaker.
Thank you very much. Honourable members, we have 3 positions which I think we need to study. Equally, the Honorable Zou had given notice of an intention to move a motion relating to the NSSF access, and I told him that he would speak to that motion when we are debating this issue. So I want us to defer debate on this until tomorrow. Members should go and study the 3 reports so that we can have handle the bill tomorrow. Is that okay, members? Okay. And also, I don't know, there's nobody whipping. Can I ask the whips to whip the members to come tomorrow?
We are going to also, through Madam Speaker, let us whip the Honourable Minister who has given us time to whip fellow ministers and above all the Prime Minister. We need the Prime Minister here. He has every privilege that makes him move. He's not a constituency member like us, but we need him here because he has to report to us. And when the ministers don't appear, he's one of them. He's the leader of government business. Honourable Speaker, maybe to say something brief. I was meeting Honourable Chintu Musyoka, the former Prime Minister of Uganda, and I asked him the difference between the current Prime Minister and himself. He said that by that time, for him, he was a Prime Minister of Uganda. And for us now, we have the leader of government business as the Prime Minister. And that is his way of posing that that was his category by then. So if this one is the leader of government business, they are 3 in number. And even is not a member of parliament. He can appear here. Let him be here to give us information and with his ministers. Otherwise, for us, we shall do our work as we've directed. Thank you, Madam Speaker.
Okay, members, please. Yes, Honourable Gwal.
Right, Honourable Speaker, I'm rising on procedural matter, and it is a matter of great concern since we returned from the primary election. Right, Honourable Speaker, as you can see, again we experienced it yesterday, that here we are debating matters of great importance, and particularly when it comes to bills. We want a dialogue between Parliament and the originators of the bill. And now it appears the Minister in charge of gender and social development is here because he is keenly following this particular bill. In other words, if this particular bill was not on the order paper today, possibly we would not even have been here. So, Right Honourable Speaker, I think it's important that this matter should be raised with the head of state, because Parliament is now going to be incapacitated, because we can't function without the implementers of the policies which we pass here. It is a very serious observation, Right Honourable Speaker, and I think the absence of the Prime Minister's team, because Prime Minister's team and the ministers responsible for the various sectors, and they are not one in a ministry, there are several in a ministry, and for all of them to choose not to be there, a big statement is being made, and it is important that that statement should be made public. We debate it, and we arrive at which way to go, because right now, Right Honourable Speaker, you may be blamed, the House may be blamed for having not passed certain bills or resolutions, when actually we need both sides of the House. And I'm raising this, Right Honourable Speaker. I'm sorry if it is misplaced, but it's a very serious observation. It should be brought to the attention of the President, who is the head of state. We should know which way is taking this country. It is not the fault of Parliament that primary election was held, where some people lost, some people won. But for us as Parliament, as long as you still have a mandate to represent your people, whether you have lost or you have won, you must be in the House. And we are trying our best, as you can see. But the front bench have decided that they are going to boycott the parliamentary meeting. Now, why? Parliament was not responsible for the election. So, Right Honourable Speaker, I feel that we cannot continue like this. Tomorrow will be the same thing. The next week will be the same thing. So can some action be taken? And Parliament be assured tomorrow by the head of state that he has also observed what is happening and he has done something about it or is going to do something about it. Thank you, Right Honorable Speaker.
Thank you, Honorable. Well, indeed, the matter you raise is very, very important. You know, in this country, you find the cabinet ministers sitting in the cabinet and reporting that Parliament has failed to do certain things. And because we are not there, there's no one to speak for us. So on the matter of these bills, yes, someone accused me. So I asked the chair of the meeting to list down the bills which have not been passed. I said list down the loans that have not been passed. List down the budgets that have not been passed. They could not raise anything. But if I had not been there in that meeting, that's the impression that work has not been done in this house. So it is really important that we press on record that we are not able to proceed because it's the ministers who are not here. Before we went for the primaries, all these bills were there, the ministers were not here. And they accused me. But I've given notice that we are supposed to stay here until the independence recess. Honour Minister, we shall only adjourn for the independence recess because it is close to the nomination. So until then, you must be here to work. Ministers, everybody, members must come back here and finish their work. And we are still on duty until May next year. Whatever the outcome, whether you've won or lost, you are on duty until May next year. So, shall we go to item number 13? There was another bill for second reading.
Item number 13, bill second reading, the Constitution Amendment Bill 2019.
The mover? Oh, the minister is not here.
Thank you, Right Honorable Speaker, and I thank you for giving me this golden opportunity that I've been longing for. And I beg to move that the bill entitled the Constitution Amendment Bill 2019 be read for the second time. I beg to move.
Are there seconders? Seconded.
Okay.
Justification?
Okay.
Seconded.
Thank you. Madam Speaker, the bill entitled the Constitution Amendment Bill 2019 seeks to amend the Constitution in the following particular areas. 1, it seeks to amend the provisions of the Constitution relating to the constitution of the Electoral Commission, and in particular, the appointment of members thereto, the disqualification of members, the terms of service of the members, and other matters related thereto. Secondly, Madam Speaker, the said bill intends to amend the provisions related to the Constitution of Parliament, particularly by doing away with the representation of the military. 2, by restricting the number of ministers, restricting the number of people appointed as ministers to be not more than 21, and also removing those appointed as ministers from being members of Parliament by way of representing constituencies. The bill also seeks provide for the office of the Attorney General and Deputy Attorney General as ex-officio members of parliament and therefore professionalize that office. The bill seeks to provide for the Speaker's panel and also seeks to provide for the involvement of the Parliamentary Commission in the appointment of the clerk to Parliament. The bill further seeks to allow political parties or organizations, all voters, to challenge a presidential election. It further seeks to restrict the presidential term to 2 terms only. Further seeks to replace the office of the Vice President with the office of the Deputy President, and also provide for his election as a running mate of the President. The bill seeks to repeal the office of the Prime Minister, and further seeks to provide for the appointment of the Attorney General and Deputy Attorney General by the President on the recommendation of the Judicial Service Commission. The bill seeks to increase the tenure of office of the members of the Public Service Commission from 4 to 5 years, and to mandate the Public Service Commission to determine the salaries and allowances of public service officers under Chapter 10 of the Constitution. It further seeks to mandate the Public Service Commission, the Education Service Commission, and Health Service Commission to appoint persons to hold or act in the respective office of the rank of head or above, other than the current norm where the appointment is by the President. The bill further seeks to repeal the office of the Resident District Commissioner, and further seeks to establish the functions, establish and provide for functions of city land boards and other related matters. I therefore implore members to consider this bill in the interest of the democratic principles of our country and for the future of this country, and pass it as proposed. I beg to move.
Thank you. Honourable members, do we have a report, the report of the committee? The report is, the chair is not here. Okay, we have received the second reading. The debate will abide the presentation of the report of the committee. So now members, it seems that taking into account all the circumstances, we've come to the end of today's business. I adjourn the House tomorrow at 2 p.m. The whips of all the parties must ensure that the members are here. The Minister for Gender must ensure that the government is here tomorrow. You are not on leave, you are not on holiday. They must come, all of them. Okay, House adjourned, 2 p.m. tomorrow. And he has to
Uganda, the land of sunshine. Breathtaking, stunning sights, incredibly extensive large greenery. Variety of wild animals and bird species. A wide range of luxury holiday facilities. Diverse, rich culture. The home of beautiful, welcoming, hospitable people. Uganda, the Pearl of Africa.
So there are many things we have done which touch, and really most of these are for the ordinary people.
Unemployment. For example, poverty. For example, corruption.
Those are the tangible kind of things people would want Parliament to address.
I do not see a member of Parliament getting involved in corruption unless you're talking about Parliament as an institution.
Who should we hold accountable for that?
I think that a member should be able to see what is in the public interest in this issue.
It's true. It's true.
No, it isn't.
Don't you believe all day, brother?
No. There were never any lions here.
And how would you know? I tell you there were lions. You've never seen one because I drove each one away with my bare hands.
No. I don't believe you.
Go home then, if you won't listen to the truth. I don't have time to waste on children who don't respect their elders. Go. And what can I do for you, little one?
I wish you were my papa.
Nonsense. Hurry home now, and I promise not to tell your father what you've said. Get along now. Oh, Father, I love children so. It's been 10 years since you promised us one of our own. As thy day of promise passed. They said you wished to speak with me. Is your servant well?
Hagar is fine.
What then?
Abram, I would love to give you a son, but I will never bear a child.
Oh, Sarai.
Please wait. I want you to take Hagar as a wife. Oh, Abram, say you will. If not for yourself, then for me.
You are my wife, Sarai.
But I'll never bear you the children God has promised.
No. The Lord promised us children. Children as countless as the stars. And he shall keep his promise.
But perhaps his promise will be kept through another. Think of it, Abram. A son. The son you've waited for all these years. God's promise is fulfilled.
You have a gift, Ishmael.
It's not a gift, Father. I've practiced long and hard.
Ishmael, if you are to inherit all the blessings God has given me, you must always recognize his hand in all the good you do. Now come.
Father, you could have sold this lamb and made good money.
I could have, but the Lord has commanded us to offer sacrifice to him.
Then use a sick or spotted lamb. Why sacrifice the best one in the herd?
Because God asked me to. Offering the best shows humility and gratitude.
Do you always have to do exactly what God says?
Always, Ishmael. Always. O Lord, please accept this sacrifice as an offering of gratitude unto thee. Ishmael, don't get too far ahead. Oh, Lord, how shall I raise such a stubborn child?
I am the Almighty God, and I desire to make a covenant with thee.
I am here, Lord.
Look at the land before you, my son. It shall be yours forever, and thy children shall have it for an everlasting possession. And from this time forth thou shalt no longer be known as Abram, but Abraham shalt thou be called.
Abraham?
And thy wife Sarai shall be called Sarah, and I will bless her, and she will bear thee a son, and thou shalt call him Isaac, and he shall inherit all the promises I make unto you this day.
My wife? A son? Oh, Lord, what of Ishmael?
As for Ishmael, I will bless him and care for him. But my promise and blessing shall lie with Isaac.
Isaac. Oh, Isaac. Isaac. Isaac, my son, my son. Oh, how your mother and I have longed for a son. You shall inherit all that God has given me. Isaac, little Isaac.
I just washed this, Isaac. Go play somewhere else.
I want it.
No! Go away! I'm sorry, mistress. I didn't notice. You weren't paying attention. I was. I just... Don't you know we could have drowned? Why must I keep track of your child?
You are still my servant, are you not?
I am also Abraham's wife, and the mother of his firstborn son.
She means to do Isaac harm.
No. No.
She does, Abraham. And Ishmael does too. I can see it.
Sarah, you imagine this thing because you love the child. But Hagar and Ishmael love him too. You will see.
Father never gave me such a celebration. Oh, are you frightened? Better not let Father see his favorite son crying. Don't get too close to the fire.
Stop it.
Watch out. Watch out.
Stop it.
Oh, is Abraham's baby crying? Well, why should you cry? Father's going to give you everything he owns. Come on, little boy. Come on, Papa's only boy.
Stop it! Go your way, Ishmael.
Surely you see it now. send Hagar and the boy away.
Ishmael is my son, Sarah.
But Isaac is ours. He's a wild and vicious boy, Abraham. If you want Isaac to live, you must send them away.
Lord, I fear that Sarah has spoken the truth. Shall I send my firstborn son away?
Be comforted, Abraham, and hearken unto all that Sarah has said. I shall protect Ishmael. 12 princes and a mighty nation shall rise from his seed. But Isaac is thy rightful heir, and he shall inherit thy promise.
Dearer than daybreak is my child, sweeter than honey is my child. Here's the day that I prayed for, to see my child at play or sleeping so near me, ever to cheer me. Always I'll praise this precious child. Comfort and bless with my love, just to see my child growing, my cup overflowing, child of my longing, my child.
Do you know why we sacrifice our finest lamb, Isaac?
Yes, Father. God has given us everything. He deserves the very best.
Isaac, there's nothing more important than obeying God's commands. Promise me, you will always do what the Lord asks.
Always, Father. Always.
Abraham, I have a commandment for thee.
Here I am, Lord.
Take thy son, thy only son, Isaac, whom thou lovest, and journey to the land of Moriah. Then go up into a mountain I will show thee, and offer him as a burnt offering unto me.
Lord, why do you ask this of me? 100 years have I waited for a child. Why, Lord? Why? Have I sinned? Show me my guilt, and I will repent. I love him, Lord.
Come on, Father. The donkeys are loaded and ready.
Very well.
We'll have to leave soon if we want to.
I said very well.
I'm sorry, Father. I spoke out of turn.
No, Here, load this one as well.
Something weighs on you, Abraham. What is it?
Nothing, the journey to Moriah is long, and I am tired.
Yes, Mariah is a long way for an old man.
Oh, Sarah.
Abraham, what is it?
Nothing. I'm just an old and foolish man. My heart is growing shamelessly tender for you. Say goodbye to your mother, Isaac.
So long, Mother.
I believe you can do better than that, my son. Hold him long, Sarah. Hold him long. When I look on this boy, I see goodness. I see your promise fulfilled. How can I destroy that, Lord? Such purity is rare. How can I put an end to such innocence? Stay here with the animals. Isaac and I will go up alone. Come.
Father, the knife.
Following your command has always given me strength. But now my heart trembles with weakness. Help me, Lord, to see as you see.
Father, we have fire and wood to make a burnt offering. But where is the lamb?
God will provide the lamb, son. I cannot understand your purpose, Lord. And yet, you are God, the giver of life. And you have spoken. I will do this thing for you.